Thank you so much, and hi guys, thank you for being in the morning here. I'm hearing this is the first on this stage today, the first for me, so thank you for being here. Thank you also, tech team, for having my presentation visible. Let's get to the topic. If you're here since yesterday, you might have had a chance to listen a few talks about AI, also legal challenges related to it. But the beauty of the topic is that I think many of us can speak about it and still show different perspectives. So 45 minutes is a time in which I can talk about some selected topics, but not get to the bottom of it. So let's begin. Obviously, that's me. I'm a lawyer. I deal with tech topics in my everyday job and game dev as well. So I decided to share my perspective on AI and creating games. A few words about the agenda. I will start with speaking a little bit about what I mean by the generative AI. Then, what are the legal issues? This is most interesting for lawyers, but also for game developers to be aware of. This is something important. Some outstanding philosophical questions, and then can we do something about the fact that the law does not answer many of them? The good news is yes, so I will leave you with a few key takeaways on how to deal with AI now, to be safe, but also to use it. There will be no message as do not use AI, because obviously we are all using it, and this is the way. This is how it's going to be. But we can do it in a conscious and safe way. So for the first segment, what is generative AI? I'm sure you are aware, but just to be sure, two stages in which we can use it. We have a human being, for example, me when I was preparing for this presentation, a big word on the slide that human programs AI. In fact, as the premiere of ChatGPT and other AI-powered chatbots and tools showed us, anyone can use it. And programming is really giving a set of instructions to an AI model in order to hopefully get an output we're counting on. For instance, I was toying with ChatGPT while I was preparing to meet you here, and I asked it to create a story about a spider lawyer, and it did. Well, my imagination was not going that far, but his obviously was. The thing is that AI can adapt itself and teach itself, and this is where the problem begins, or the fun begins for the lawyers. What you see right now is a definition of an AI system, which is in the draft of the EU AI Act. A few words about that. You might have heard about this. This is very often being pointed as the only legislation in the world that is so advanced in developing, so specific regarding the AI. Of course, European Union is not the only region in which there are talks about regulating AI, the draft of the legislation, but this is something close to us, and this is something that is kind of advanced. Still, we probably won't see the AI Act coming into force for the next few years, but it is happening, and it is reacting to the developments in the market. This definition of the AI system is important because when lawyers talk about something, they like to have a definition. The definition in legal provisions is called, of course, the legal definition, and it simplifies things because it helps to show what kind of things, in this case, what is AI, and the business who uses it or deploys it has to be compliant with the regulations, and we have to know what this, the subject of this regulation is, in this case, an AI system. They define it as a machine-based system that is designed to operate with varying levels of autonomy and that can generate some outputs. You can see examples here: predictions, recommendations, decisions that influence either physical environment, as we see it, as we touch it, or virtual one. And of course, the objectives have to be defined. They can be either explicitly or implicitly defined. When we talk about generative AI, we don't only talk about ChatGPT. Of course, it was a kind of a milestone in the discussions. I remember that a few years ago, when I was already interested in this, many people thought that this is something that will perhaps be relevant, like in the next decade or so. Well, the time showed us that it is relevant now. There are some kinds of generative AI, like text-to-image, text-to-video, text-to-audio, text-to-text, basically many of things you can imagine. And of course, what is important here is that really any one of us can use different tools, and we will get the outputs within seconds. This is very tempting, but on the other hand, this can also generate challenges for which we have to be up for. Last few words about the legal developments that we should have our eyes on is that, as I said, the projected EU AI Act is reacting to developments of the market. The first draft of it was created about 2 years ago, and it said nothing about the generative AI. I mean, not a single word. So imagine that this act is finally adopted, it comes into force in a few years, and says nothing about what happens when an AI generates creative output. I mean, it would be outdated. In a minute, it would come into force. So, a few weeks ago, the members of European Parliament decided that it has to change, and they introduced a definition of a generative AI into this act. According to this, a generative AI is a so-called foundation model. Now there is a distinction between general purpose AI and foundation models that are explicitly designed to do some kind of tasks. In this case, specifically intended to generate content, such as complex text, images, audio, or video, and of course with varying levels of autonomy. I must say that what bothers me about this definition is the word complex. I mean, if the text is not complex enough, I don't know what that means, and I don't think that European Parliament know this as for now. Then the AI wouldn't be a generative AI. Well, this creates lots of problems, and I think that perhaps when finally we have this AI Act into force, perhaps this will be adjusted as well. I have a feeling that it will be. What's important to you if you are deploying generative AI or using it is that there is an idea to put an extra obligations on you to be compliant with. The most known, there are a few of them. I don't know if this list will grow or not. The first one is the transparency about the fact that the content is generated by an AI and not by a human being. This is something that's happening already. On some websites where you can buy digital art, there is already a section not generated by AI, human-made, probably the direction in which premium market is going to go. But then imagine that AI really does create a part of your game that you're using this tool, which is understandable, and as I said, this is how it is and how it's going to be probably. How exactly do you disclose that content was generated by an AI? I mean, should you show specific frames of the game or perhaps specific dialogues? Does it matter if such content is, I don't know, like a background conversation by NPCs? Is this something that you have to specifically disclose? Would you even want to disclose, to say to your competitors, hey, we used AI for this and that? Yeah, so this is a challenge that may come into force in some time. Using the safeguards while training AI, I hope this is something that should be a standard. They say here that you should take into account the acknowledged state of the art. Well, this is probably the least problematic of these requirements. And the last one is publishing a summary of copyrighted data used for training. And we will get back to it in a few minutes, but you probably can see that this is kind of as problematic as this transparency obligation. I mean, should you just state that some copyrighted data were used? Should you show which of them, or discuss the exact basis of use? Some commentators said that EU is killing the AI industry with this. I wouldn't be so dramatic, but yes, this is something to monitor and to be aware that in the future time, this might not be drafted obligations, but obligations that are into force. But don't worry, this will be a part. This will be a part of takeaways in the end. So perhaps let's not get ahead of ourselves. Let's not be too stressed. So then, to the heart of today's presentation: legal issues with generative AI. There are lots of them. Here you can see 6 areas which can be problematic. This is not a closed list, of course. Copyright, I will discuss it. This is an obvious problem with training AI and outputs. Users, well, it is a very vague category. We can talk here consumer law, transparency towards the users, data privacy, this is connected with the users, of course. Confidentiality, this is more about you having your know-how, your ideas that you would not want to get out there too soon, and putting them into an AI model, especially when not being careful, it can jeopardize that. Defamation is basically about deepfakes. To oversimplify things. I think you all know how easy it is to make them now and how easy it is to create an impression that the person said or did something that she really never did. And commercial considerations, well, of course, this is connected with your strategy, your trade secrets, your know-how, and so on. So let's get into some more details. And this will be a very quick and high-level overview of the issues that you might encounter and the issues that you should be mindful of when using AI. I divided it into categories: legal challenges related to input stage and legal challenges related to output stage. The output stage is basically the topic of our today's meetings. Who owns it, but we'll get to there. So the first thing is using protectable IP, or frankly any kind of protected information for training an AI model. You probably heard either yesterday during other legal grade presentations or from the media that in the US there already are a few lawsuits that are about using the protected data to train AI. This is one of the examples, Getty Images versus Stability AI. It's pretty obvious Getty Images really doesn't want their images to be used without their control, without paying them to train AI models. There's also a case involving software. There will be probably more cases in the future. They are in the US pioneers in this kind of stuff, but probably it will have an impact on the whole industry. We'll see how that goes. Using of protectable IP, this is, I mean, one of the examples, and from a few years back, but one of lawyers' favorite ones, and it kind of nicely shows how protected AI can be used. This is a project at the Next Rembrandt in 2016. A group of scientists took hundreds of Rembrandt paintings, over 300 of them, and they taught AI about his style, about his paintings, and created the one you can see on the slide. And it is a new painting that might have been created by Rembrandt. Now, this wasn't this problematic because, of course, Rembrandt works are in the public domain. And this is also one of the mitigation steps that can be taken. using the protected IP that already is in the public domain because either it's old and the duration of copyright ended, or because its creators decided that it should be in the public domain from the beginning, for example, by making it available of CC0 Creative Community license. This is a nice idea. It is not always feasible because simply sometimes you would want to use IP that is not in the public domain yet. But if it's not the urge, this is something to consider. Another mitigation step would be, of course, using only licensed IP, only IP for which you have permission to use it to train AI models. I think that one of photo stock companies recently was showing off that they use only the pictures they have rights to train AI models. Of course, it is easier if you already have such a database, but it could be expensive, it could be difficult and impractical if you don't. The next thing I was thinking about was fair use. I think you are familiar with the term. It is mostly from the US law. We do have something similar in Poland and in Europe generally. It is a question whether using somebody else's work could be deemed as fair use when you train AI models. I'm not aware of any case right now that would be solved or settled regarding specifically AI, but probably we will hear about it and probably it will be a US case. Just quickly going to data privacy, you might ask me, what does this have to do with generative AI? I mean, we are talking creating images or creating texts. Where's privacy exactly in that? There could be. Imagine that you are trying to create an image of a specific person, and as an input data, you feed AI with images of other persons. So long as they are, for example, stock photos of the models who were aware that their pictures can be used for various purposes. I'm simplifying, but basically this is all fine. But if among such training database there are photos that are private or somehow scrapped from more private resources and they depict people that weren't aware that their photographs are being used for training AI model, where this is a privacy issue, it can be a problem. You probably know that the penalties in the GDPR, if we're talking Europe, are pretty high. As a side note, I can tell you that penalties in AI Act are even higher. So yeah, this is something to have your eyes on. You also may have heard that Italy banned ChatGPT. This is what you could have read in the press. They didn't ban it as that Italians cannot use ChatGPT anymore, but yes, the Data Protection Authority in Italy was concerned that the user's data may be used to train ChatGPT in an uncontrollable way and that privacy can be at risk here. So this is something to remember and to have in mind. The next thing, confidentiality. Well, this is simply a matter of not putting your confidential data in the internet, for example, into an AI model without controlling it, because it can not end well for you. Sometimes, very often, these AI tools have a clause in their terms and conditions that they will use your input data for further training. And if these input data are, for example, a confidential new IP you're working on that you don't want to show to the world too early, this is when things can get rough, and this can be a big problem for you. It can be a problem for if you are developing your own game, which is still confidential. It can be a problem if you're a subcontractor for another client, and you not only have to protect your own data, but their data as well. It can be a problem if you're a client and your subcontractor decides to use AI and, well, it not goes as it should have been, and confidentiality is compromised. Let's get back to the overview of the legal challenges, and let's move to the output. to the two big questions. Who owns the output made by an AI, with the use an AI, generally the outputs that are a result of using the generative AI, and is it protected at all? And here, it's a very big legal challenge, one that is not being answered for now, because as you may know, copyright, this is the legal regime that it's being revoked most often when we are talking about the results of using generative AI. It's a set of rights that are given to human beings. And when an author, let's say, of an output generated by an AI is not human, then we can ask ourselves what to do. There is no answer in Europe, in the US, or really anywhere in the world to that, and I don't think it will be very soon. Who knows, maybe I'm mistaken and I will tell you about it in a few years, but for now, this is kind of a blank area. What I'm showing to you now is one provision from the UK Copyright Act, which is, as you can see, from the 80s. And this is a classic example of what law could be. In the UK, they say for quite some time now that if there is a work that is computer generated, whether it is a novel, a dramatic work, musical, or it's a very broad term, artistic work, then there is also always a human author, and this author should be a person who took the arrangements necessary for the creation of the work. When we try to discuss AI, looking at this provision, we can ask ourselves who this person is. Is it me if I give a set of instructions to an AI model, even if they are rather primitive and very simple? On the other hand, is it the person who created an AI model? I mean, if it not were for them, I wouldn't be able to use an AI model at all. This isn't obvious, and this is a question that remains unanswered for now, but it connects with another one. Is the result of generative AI work protected at all? You probably all know this monkey. His name is Naruto. I'm not sure if it's still alive, but it will be immortal in the heart of the lawyers who deal with copyright, IP, and generative AI. This is because this monkey took its own selfie, a few selfies, actually. I think the best one is visible on the slide now. And in the US, of course, it posed the question, who owns it? Can the monkey be an owner of the photo, of copyright to it? This is not only a question of philosophy, but, for example, a question of earnings. The owner of copyright has some exclusive rights to copy the work, to distribute it, basically to make money of it. So this was a very valid question. In this case, monkey didn't get to be the owner. Nobody did. And this was a fun case a few years ago, but we cannot really compare the actions of a sweet monkey to actions of the AI algorithm who is capable of learning itself. I mean, this is not the same situation, but for now the monkey case is really all we have here. So, getting back to our questions, now that you know that I don't really have a clear answer for you, there are two more things that we have to consider. Can the output of generative AI can be used at all? And what about if it, for example, infringes somebody else's protectable IP? Like, for example, what if an image is a plagiarism? What if the text we generated is someone else's novel but just slightly changed? As I said, the law does not give us a clear instruction to this, which is why it is very important when using AI to try and mitigate that risk, to try to use a set of tools and procedures and be mindful when using AI to try and avoid raising these questions. Because if things go down to, for example, a dispute between you and the person who claims that her work is infringed by any output you were able to have by using generative AI, this is when things will get very difficult, and this is something you would want to avoid. Let's move on further, and let's see what's next in store. And the third part of my presentation are outstanding questions. I already asked a few of them today. So first of all, is an AI a tool or is it a creator? You may not be aware, or perhaps you are, perhaps you remember that when computers got into the game and the creators started using them, for example, for writing their novels, there was a question, is it human author anymore if he's using a machine to create and not, his own hands to write? Of course, now we can laugh because it's obvious that if you use any kind of word generator to write a text, you are the author. But then again, word generators don't usually learn, and they don't use the input data to become better, and they not create the results, like, for example, a novel within seconds. If you ask artists, they would probably tell you that AI is only a tool. But if you look at the growing use of it and its ability to create even cinematic pictures within seconds, then you may start to wonder, is it really just a tool? If it's not, then we have to ask ourselves what are potential authors of whatever AI generated. I already said that in the UK, this might be a person who kind of arranged the output to be possible. Who is this person remains unclear. It could be a programmer. Of course, when I say a programmer, I don't mean a single person. This would be usually a team of programmers, and in the end, there would be a company. Perhaps the people who invested, who were able to create a generative AI, should benefit from it. Perhaps they should be deemed as authors. It may seem fair in a way. It protects the investments made, both monetary ones and the mind ones, the ideas, all the hard work. But then again, if let's take ChatGPT, for example, is created once, should its creators always own everything it makes? It does not seem so fair anymore, right? So perhaps the user. It could seem justified. I mean, I use the tool, I made input instructions, so I own whatever is created. But on the other hand, what if my instructions are really primitive? I mean, I write, create me a spider lawyer, and it creates it, but I didn't have anything specific in mind. I was just being fun. Am I really the author here? I may not feel that way. Then the third option is the one that is widely discussed and always is exciting. I mean, giving some rights to an AI itself. We will not go there in details because it would require us to think broadly about if AI can be any kind of a person, and I don't mean human being in a philosophical sense, but can it have like a legal personhood? Does it need it? Is it justified in any way? These are the big questions that would have to be answered first. Joint authorship between programmer, user, AI, whatever, it does not really give us an answer. But the last option is quite interesting, and it says no one. It says that if AI generates an output, this is not something that should be protected. This is made by a machine, and that's okay, but there's really no one who should be protected with proprietary rights like copyright. And it might seem tempting, but then again, let's think about the consequences it would have. if you would create parts of your game using AI and, for example, some frames or some dialogues. Maybe not the heart of a game, but still some part of it. And then they, for example, leak. If they are not protected, anyone really could use it. It doesn't sound so good, I think. And it would cause a huge uncertainty in the business. I mean, I could even imagine like a war to obtain somebody else's outputs made by generative AI just to freely use it. It's not a good option either. As I said, personality within AI is a very big, very philosophical question, and I don't think that it will be solved anytime soon. So let's move on to the more interesting idea, which I personally like. This is just to mention that it is a possibility. Perhaps we should create a very own rights for whatever AI is creating. Let's abandon copyright. Let's not mix human authorship with the use of AI. Let's think about something else. Let's regulate it once and for all, just to make things simpler. But let's do this by the set of the new rights that could be tailored to AI. I don't know if you're aware, but there is something very similar when it comes to databases. Databases are not exactly artistic works, but they do require a lot of effort to be made and a lot of investment. And there is a law, it's an IP law, that protects whoever made that investment and gives him some kind of unique exclusive rights to copy databases, to use them in a specific way. So perhaps this could be the way in which we could protect the outputs by AI. I like this idea. But then let's move aside philosophical questions, unsolved legal challenges, and let's think, what can we do, what can you do when you use AI to be on the safe side? All that I said was to show that lawyers and regulators all over the world do not have straight answers what to do with the generative AI. They will try, and they will try to define it, to impose some obligations on companies that are using it, but still we are not in the heart of the challenges that it poses. But it doesn't mean we cannot do anything, and I created a short list of good practices that can be observed, that can be used if you are involving AI in your everyday business. Just not to resign from using it, but to try and avoid disputes, try to avoid problems and situations in which all of these unresolved questions would really have to be asked. So the first thing on the top of it is establishing policies. I mean, just within your organization, tell the people if they can use AI. There are some businesses that completely ban it because out of fear that confidential information may leak, that copyright issues might get in the way, and employees or contractors might create plagiarism without even knowing it. It is really a good idea to sit, to think whether we want AI in our business and how it should be used. And the next step is to write it down. It doesn't have to be a very formal document, but at least a set of rules. Basically, talk to your guys and together with them establish how they can use AI, if any. The next thing is reading terms and conditions. Of course, I mean terms and conditions of AI tools, because there might be some surprising things there. These terms, these OLAs are usually long documents. Nobody wants to read it. But if you do, you may discover that, for example, creators of an AI model assign copyright to you in any outputs that you create. and they might say that input is also your property. But then again, in the third sentence, they might say, but we will use your input to further train our chatbot, our model, our whatever. And then it is kind of red flag because it basically says that whatever you put into an AI can be used further and you may not have control over it. But also there might be another situation. Perhaps you will be only licensed the inputs of the generative AI made based on your instructions, and this would be much less comfortable situation. As game developers, you want to have whole IP to your game, not some of it. And certainly you wouldn't want any key parts of IP be owned by someone else and just licensed to you, especially if it is just an AI model used, for example, by the developer to make their life easier. This is okay, but you should be aware of it. The next thing is more applicable to you if you wish to train AI models and then use them. If there is a data set you would like to feed to an AI, you should generally make sure that it's not shady, it does not contain some protected IP that you don't know about, or, God forbid, personal data, or anything else that shouldn't really be there. You can achieve it by building a training data set yourself, which would take a lot of time and would not be probably practical. Or if you buy data sets, you may want to have a proper agreement with whoever you're buying it from to check such entity, whether they're credible, and so on. Which brings me to the next thing, paying attention to the agreements. And here, I not only mean agreements with, for example, providers of data sets, or agreements with the creators of the AI model, meaning terms and conditions. But also, I mentioned that you could be in two situations. You could be a subcontractor for some other studio. You can be the client, and you can have subcontractors. When you are signing agreements, I think you should spare a thought or two what happens if you or your counterparty wants to use AI. Are you allowed? Do you allow that? Are there any conditions? Perhaps there are some models you would not like to be used. These are all things you can agree on, and it's best to do it in writing, of course, so paying attention to the agreements is kind of a big thing. And the last point might sound a bit philosophical, like all this topic, to be honest, but being mindful is a very important thing. It means that using new technologies is really okay. There's nothing wrong with that, but when doing it, it is really great to be aware that there are downsides, there are merits of using it, there are some challenges. We don't have to call them problems, but challenges that may have to be addressed. And the best rule is to address them before they really become a pain for you. Also, when it comes to legal regulations that may come into force in some time regarding the AI, regarding the use of it, they may force you to be compliant with, as I said, for example, transparency obligations. It is good to have your eyes on such regulations and to try and prepare to be compliant or to find a way how to adjust your business to it before it is really an obligation, and failing could cost you a lot of money, a lot of penalties, or even bad PR or whatever. You generally want to be one step ahead of the problems and the regulators. The good news is that we are lawyers, so we are interested in the least fun things when it comes to AI law. But you can take advantage of that and ask your lawyers what the newest developments are, just to be mindful and always one step ahead. So this was really quick. I am very grateful you were with me. I'm not going anywhere if you would like to discuss further. And while this might not be the greatest part of an AI, but nevertheless, it is quite important for you. So thanks for being here. It was a great pleasure.